The Appellate Division First Department is now in session. Good afternoon and welcome. I will commence with the call of the calendar. Council, please pay attention. People versus Peter Santiago is submitted. Essex Cement versus Extreme Ready. Appellant's counsel, Mr. Ripa.
Yes, Glenn Ripa here for the defendant.
Good afternoon, Mr. Ripa. You have been granted 4 and 1.
Okay, thank you very much.
You're welcome. Mr. Magalith for respondent.
I am here. Good afternoon.
Good afternoon, counsel. You've been granted 4 minutes.
Thank you.
Counsel for L. Anthony versus Bernadette R. Ms. Malin?
Malin it is. Good afternoon.
Malin. My apologies. Good afternoon. You've been granted 4 and 1. Mr. Ward.
Yes, Your Honor, present.
Good afternoon, Mr. Ward. You've been granted 4 minutes.
Thank you. Good afternoon.
Good afternoon. People v. Timothy Buchanan. Ms. Mitter.
Yes, good afternoon. Alexandra Mitter for defendant.
Good afternoon. You've been granted 5 and 1. Mr. Kress.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 6 minutes. Hyman versus Able and Ready is submitted. People versus Isidore Fidelis is submitted. Perez versus Live Nation. Mr. I'm going to ask you to tell me how to pronounce your name so I don't mangle it.
It's a fine Irish name. Kapowski, Your Honor.
Kapowski.
Tim Kapowski.
Wonderful. Welcome, and you've been granted 8 and 2, sir.
Thank you, Your Honor.
Mr. Morelli.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 10 minutes.
Thank you, Your Honor.
WVH Housing versus Brooklyn Installation. Appellant, Ms. Ayala.
Good afternoon, Your Honor. We've been granted 3 minutes, I believe.
That is correct.
Thank you.
And respondents have not requested any time. Number 9, Atsko Footwear versus KBG LLC. Mr. Catterson.
Good afternoon, Judge.
Good afternoon. You've been granted 6 and 2.
Thank you, Judge.
You're welcome. Mr. Sherwin.
Good afternoon, Your Honor.
Good afternoon. You've been granted 6 minutes.
Thank you very much.
Century Lane versus Nature's Bounty. Counsel for Appellant.
Good afternoon, Your Honor. This is Renee Zaitsev.
Say that again.
Renee Zaitsev.
Zaitsev. Okay, welcome, and you've been granted 5 and 1.
Thank you.
Ms. Thompson.
Counsel for respondents here.
Good afternoon. You've been granted 5 minutes.
Thank you.
You're welcome. People v. Theodore Dalton is submitted. Simon versus Moskowitz is submitted. Davis versus Port. Appellant, Mr. Brenner.
Good afternoon, Your Honor. Eric Brenner on behalf of Plaintiff Appellant.
Good afternoon. You've been granted 7 and 2. Respondent for Defendant Port.
Good afternoon, Your Honor. Jean-Marie Atamian on behalf of Mr. Port from Mayor Brown.
Good afternoon and welcome. You've been granted 3 minutes. And respondent for Cerberus.
Cerberus, Your Honor. Andrew Gladstein, Schulte Roth. How are you?
How are you? Thank you. And you've been granted 5 minutes, Mr.
Thanks,
Gladstein.
Your Honor. If it's not too much trouble, I think we've coordinated, and I think Cerberus will be going first in the argument, followed by counsel for Mr. Port. I don't know if you're reading off the schedule of anticipated order, but that's how we intend, if there's no objection from the court.
I have no problem with that.
Thank you.
Okay. Let me just make that notation so I don't forget. All right. Reham Corporation versus Brennan is submitted. GCS Second versus Merchants Hospitality. Mr. Alonso.
Good afternoon, Your Honor. Mark Alonso for the appellant.
Good afternoon. You've been granted 5-1, and Mr. Kogan for the respondent.
Good afternoon, Your Honor. Harris Kogan of Blank Room.
Good afternoon. You've been granted 5 minutes.
Thank you,
Louise versus Hampton Jitney is submitted, and Coyote versus Go New York Tours is submitted. First case to be argued, Essex Cement versus Extreme Ready. Mr. Ripper, you have the floor.
Okay, thank you, Your Honor. Your Honor, this case is the lower court judge granted the plaintiff's motion for summary judgment against my client, Michael Falco, and it's based on a personal guarantee. Our argument is that there was a substantial questions of facts in dispute with respect to this, and according to the CPLR,
What are those questions of fact?
The questions of fact, Your Honor, were that we challenged the fact that the salesman, the sales rep, who Mr. Falco was dealing with, he rescinded the personal guarantee and agreed to continue to sell him without a personal guarantee. And
Was that rescission in writing?
No, it was not, Your Honor. It was an oral conversation that my client had with the sales rep, and the sales rep made that representation to him, and he relied on that representation with respect to the sales rep and continued to purchase from them, with his company being liable for it, with him with the understanding that he would not be personally liable. The sales rep has the right under respondent superior to represent this situation. He was an authorized representative.
Counsel, didn't the agreement under paragraph 11 specifically require that to terminate the guarantee, it had to be in writing via certified mail and received at the regional office in Richmond, Virginia? And it is conceded, I believe, that that did not happen.
No, that is true.
How do we get past that very clear and unambiguous language?
Because my understanding of the way that contract reads, that rescission is the defendant, the Michael Falco, being the one to rescind it. If the company wanted to rescind it, they didn't have to go to their headquarters and say.
But the language doesn't refer to Mr. Falco, or it says very clearly, whoever does the rescinding, it must be done in writing and sent via certified mail to the regional office in Virginia, and that clearly was not done.
It doesn't say that, it doesn't specify that who the rescission they're talking about, but it's the contract written by the company that's selling the product. And why would the salesman have to notify his own company that he was rescinding the contract and put
because the contract says so?
But the contract, I believe the contract has to be read that the rescission would be a rescission by the purchaser, not by the company that is providing the merchandise. If they want to rescind it, they don't have to notify themselves that they're rescinding it. It doesn't make any sense. If the company wanted to rescind it from the purchaser, there would be no reason why they would have to notify their own headquarters in writing. They're the ones making the determination.
Well, apparently they didn't want to rescind it because they're suing on it.
Well, that is right. Maybe headquarters did not want to rescind it, but the fact is their representative made the representation that they were rescinding it, and my client relied on the representation made by the authorized representative of Essex Cement, and he continued to buy with that understanding. And we're arguing that there's promissory estoppel here. My client was promised this by the salesman, and that he relied on that, and he relied on it to his detriment.
Thank you. You have some time in rebuttal. Mr. Magalit? We cannot hear you if you are speaking. Please unmute your mic.
Can you hear me now?
Yes.
Sorry about that. I think this is a very simple and straightforward matter. The guarantee that Mr. Ripper keeps talking about is
I can't hear him.
You have to speak a little louder, sir.
Is this better?
Yes. Keep your voice up.
Okay, I will do that.
Thank you.
The guarantee that Mr. Ripper is talking about is what's called the continuing guarantee. And Justice Borak correctly said we can't grant summary judgment on the continuing guarantee. But he granted summary judgment on the original guarantee, which Mr. Falco admitted signing and acknowledged that it was his signature. And Justice Borak found that that was never terminated and remained in full force and effect throughout the life of the arrangement, the business deal. The argument that is suggested by Mr. Ripper, which is that Essex decided they didn't need a guarantee, so that they had their salesman tell Mr. Falco that they no longer needed a guarantee, is just not credible in light of what's in the record. Mr. Strobel, my client, put in an affidavit that said they require a personal guarantee with all new clients. The first sales were made in July. The first invoice would not have gone out until September. And yet Mr. Ripper, 2 weeks into the relationship, when there were barely any sales and no payment history, that they no longer needed a guarantee. And I think Justice Borak was correct when he found that it was clear and unambiguous. There was never a termination. It would have made no sense for Essex to terminate its own guarantee. If Mr. Falco wanted to terminate it, there was a clear procedure that was not followed. And we submit that under the standards of review, there is credible evidence in the record to support Justice Borak's decision. There are inferences that are reasonable that can be drawn. And we submit that Mr. Ripper's argument that the alleged offer to rescind the guarantee and replace it with a continuing guarantee is not only legally incorrect, Justice Borak also addressed that when he said there was no novation, and by Mr. Falco's own admission, the original guarantee was never terminated, and therefore we believe that there was no error that warrants reversal. And if there are any questions, I'd be happy to answer them. If not, I rest.
Counsel,
Now,
I don't see any questions. Mr. Ripper, you have a minute.
Okay. There are two significant issues here. One is our argument that whether there's a substantial question of fact, we can't have summary judgment. And what is critical in this case is that the salesman came to Michael Falco with a request for him to sign a continuing guarantee. He refused to sign that continuing guarantee, and the salesman forged his signature on that continuous guarantee, and that was submitted, and that's clearly a question of fact and makes this whole issue an issue that we need a trial to determine the facts here. We have a continuing guarantee that was forged. We have our client representing
what invalidated the original guarantee?
The fact is that the salesman represented to him that for him to continue to do this, he needed an additional guarantee. Why they felt they needed a continuous guarantee, I don't know, but that was the representation made by the plaintiff to my client. There's a continuous guarantee in there. There was a continuous guarantee that was requested. They produced it to us. It's forged. It doesn't have my client's signature on it. And clearly that raises enough question of fact that this should not be determined on a motion for summary judgment. We should have our day in court.
Thank you.
Okay, thank you.
L. Anthony versus Bernadette R.
Are we done in terms of leaving now?
Yes, you may, sir. Have a good afternoon.
Okay, thank you very much, Your Honor. And thank you, Howard.
Okay. Counsel for appellants.
Good afternoon, Your Honors.
Good afternoon.
This case comes before this court due to a patently unreasonable award of childcare to a custodial parent who does not work, who offered no evidence of payment of a childcare expense. And to the contrary, all the evidence in the record shows that there should be no award of childcare. Under New York laws, the court is respectfully aware, a custodial parent may be entitled to a pro rata share of a reasonable childcare expense when they are working, seeking work, receiving education, or receiving vocational training that would lead to work. And in this case,
are you arguing, counsel, that taking care of a special needs child with the multiple layers of difficulty that this child has is not a challenging situation for even your most adept parent?
Certainly, taking care of any child, let alone a special needs child, is absolutely.
And so this mother should be on call 24/7 without any assistance whatsoever as far as your client is concerned.
Well, Your Honor, I think
mean, that's what you're arguing. She's not entitled to any assistance, no break from a child who requires around-the-clock care. Is that your argument?
No, Your Honor, that's not my argument. Under Family Court Act Section 413, it specifically delineates when an award of child care is appropriate. And it doesn't say in Section 413 of the Family Court Act that a parent taking care of a special needs child qualifies for an award of child care. So while it is very, I'm sure, difficult and at times hard for the mother to care for the child, this is what the Family Court Act designates as what is inappropriate for an award of child care. So
tell me precisely what language in 413 would say that she is not entitled. What language are you relying on that this court should hang its hat on to say that this mother should get no assistance?
Your Honor, I think there's nothing in the particular statute that says that she should get no assistance, but I think the question is, what's a reasonable award of child care?
And your argument and your client's argument is that she's entitled to nothing, that she has proven nothing. Well, that's how you opened.
Well, our argument is that she failed to prove that she has a child care expense. And the history of this case is that the mother has made repeated misrepresentations to the court over and over again, and that her credibility has been called into question. So after lying, for example, to the court about her rent expense and telling the court and testifying under oath that her rent was $5,000 a month, when her rent was only $2,500 a month, she made a misrepresentation to this court. She also misrepresented to this court that she had a health insurance expense for the child when she did not, and the child was covered under Child Health Plus, and she was paying absolutely nothing.
That's all well and fine.
Right.
But the bottom line is the best interest of the child, right? At the end of the day, even if someone is proven a liar or a deadbeat, right, the child is still what should be at the core of our decision making, correct?
Well, I think the
best interest of the child, right?
That would be, Your Honor, I would submit that in the case of a custody case, that would be the standard.
Not in child support.
I don't see anywhere in the statute.
To live with is in the best interest of the child, but how the child is supported and maintained in good health and all of the things that make a child a healthy child, that doesn't matter. We shouldn't consider best interest of the child for those things.
Your Honor, I'm not aware that there's any case law that says that, and I would say that if the mother were working or had proof that she was working, then an award of childcare would be appropriate. But if she has no reportable income on her income tax returns from 2015 to 2018.
But again, you are equating working with an income. I would dare to say that across America, there are a lot of women who stay home and take care of their families. And I would argue they'd say they're working. They may not be employed and earning a salary, but they are indeed working,
Absolutely.
as is this mother. So why should she not, again, the question goes back to the same thing. Why should she not be entitled to assistance?
I think the issue here is not that she shouldn't be entitled to some assistance. I think the question is what is reasonable. And based on the mother's own testimony, I don't think that the mother testified at the trial that she was paying her child care provider for 40 hours a week of childcare, which included the times that the child was in school.
And didn't the court cut that back to 25? So really what we are deciding is whether 25 hours is unreasonable, right? The court cut it back.
Well, the court cut it back from what the mother was claiming it was full-time.
I understand, but what we are deciding is whether 25 hours of assistance to this mother who is on call 24/7 for this child is reasonable. That's the issue for us. Do I have that right?
And also, yes, in part, the amount that the mother is paying for her child care provider was based on her receipts, if the court is to consider the receipts, which we don't believe are appropriate documentation of the expense, because the mother claims she's paying for everything in cash and there's no documentation for any of it. So if she actually had an expense and was able and verified that expense, then perhaps, she should receive some sort of child care. But when you when you have a history of
but didn't the mother offer an explanation which the support magistrate found reasonable as to why she had to have this person on call, pay to keep them available for more hours than they were possibly actually physically in the same, physically taking care of the child? Because the child has so many issues and so many problems that to find a caretaker who can care for this child is very difficult. And she never knows when the child is going to be in need of help due to certain of the child's issues. So there was an explanation given.
Right. I mean, and yes, the support magistrate concluded generally that 25 hours a week of childcare was what was appropriate. But again, if the mother testifies that she's paying for 40 hours of childcare, and that includes the time that the child is in school, then she's being awarded childcare for times that the child is either in school or that the mother is paying the child care provider, if we believe she's paying the child care provider based on her cash payments, which there's no evidence of, that she is paying for somebody while that person is either at their mother's house or was at a Starbucks.
Well, that was my point. My point was she gave an explanation for why she had to do that due to the child's various special needs. This is your client's child, is it? He doesn't deny that.
It is his child.
Yeah.
Counsel, I just have a question because, I mean, certainly there's testimony. The mother provides testimony about how she created the invoices, the neighbor testifying about witnessing the payment. So really, this is about credibility. And so why shouldn't we defer to the hearing court's determination of credibility here?
Your Honor, there's a very long documented history of the mother's lack of credibility in this case. The mother testified.
But counsel, we have to focus on the record right here. So the bottom line is the mother provided an explanation, as Justice Mazzarelli indicated, her practice of creating the invoices, the witness testimony about observing the payments, and identifying the child care workers. So we're not talking about what happened in the past. We're talking about this record. Obviously, the hearing court found the testimony credible. Why should we disregard that?
Well, the testimony that the mother gave was that she creates these receipts, as she calls them herself, and she gives them to the child care provider, and the child care provider signs the receipts, but that there were no child care workers that were called in to verify that. And if the mother has no income from 2015 to 2018 on reported income, how is she able, the question becomes, how is she able to pay for those childcare providers? And then she testified that she borrowed money, but all of these payments are in cash. So anybody can write out a document and say, I paid somebody in cash for something and demand payment for it. But if there's no—
Thank you. You have a minute on rebuttal.
Okay.
Okay. Mr. Kress. No, I'm sorry. Mr. Ward.
Thank you, and may it please the court. I am Brett Ward, and I represent the respondent in this matter. Your Honors, caring for a special needs child in a family is a very difficult thing. For a mother to take care of a special needs child on her own without childcare is impossible. And that is exactly what the appellant is asking this court to do. Since the day this child was born, Chaz has been raised solely by his mother. The father has chosen to play absolutely no role in this child's life. Not when he was born, not when he was diagnosed with his special needs, not when his special needs became even worse, not when the father attempted to rekindle the romantic relationship, the rejection for which led to his downward modification petition before this court, even though it was found that he was making more money at the time. When Mr. Lombardi comes home from a day of his, I'm sorry. Oh.
Mr. Ward,
Yes.
This is Judge Oring. I have a question, and it centers around the whole testimony, this child care issue. I heard counsel was saying that the mother didn't call the child care individuals in. Did the father know the names of these child care providers?
He certainly did. There was testimony.
So he could have called them in. If he could have, he could have subpoenaed them, right? In the sense to rebut or at least counter what the wife was saying, right?
Absolutely, Your Honor. I'm just going to say that's the mother. It wasn't a wife. They were never married. But yes,
I'm sorry. Okay,
exactly what you said is correct. In fact, the father put in no testimony at all. None of the mother's testimony, none of the witnesses she brought in to talk about witnessing the child's special needs, witnessing the nannies were there in the daytime, in the evening, on the weekends, while my client was working. She was just, and Judge Manson Daniels, you hit it right on the head. This wasn't someone who went to a 9-to-5 job because she couldn't have one. When she went to the interviews and she had a stack of papers, and you may not be able to see with my hands on this virtual, but this high that she put into evidence. The problem is she had to say to each employer, you need to know, I may have to run out the door on a moment's notice because a fire engine may go by the school and my son will be inconsolable for hours and I have to leave. And employers were not interested. So what did she do? She went out and ran errands for neighbors for $10 at a time. She became a parent advocate for other parents of special needs children, maybe made $25 or $50. And yes, her income never made it to the level that she had to declare it on tax returns. And that's why she had to pay for this child care by taking money out of her 401k and incurring the penalties. She had $135,000 in debt at the time of the trial. And I want to say, Your Honor, Mr. Lombardi was never authorized to stop making these payments. He owes her over $100,000. He asked Support Magistrate Borowski to relieve him of this obligation, pendente lite. Referee Borowski, Support Magistrate Borowski said no, and he still continued not to pay. And he also continued not to pay the unreimbursed medical expenses. And if you want to talk about credibility, Mr. Lombardi's explanation is, I didn't have to pay because she never gave me receipts. And then he admitted at trial that he blocked Ms. Rivera from all forms of communication so she couldn't get him the receipts. That's the credibility issue in this case. She is doing what she can do to survive. And that's really where it is. She comes home to see Die Mom carved in her cabinets. Okay, I would argue that the lower court erred in cutting back her time because she very credibly testified. You can't have temporary child care workers with a special needs child who has so many issues. There has to be familiarity. And the truth is you have to pay someone full time because if you don't, no one's going to work for a couple of hours to be hit and thrown at. This child broke his mother's tooth. He screams, he hits, he takes knives out. You're not getting the local neighbor down the street to babysit for a couple hours. You need full-time help and full-time pay, whether you're going to work 15 hours or 30 hours.
He's 15 years old now, right?
Yes, he is.
Oh, okay.
And I submit to you, Judge, with special needs children, it gets harder when they get older because they can hurt you. Okay. And as the behaviorist talked about, and Your Honor, you had referenced this, some of this is safety for this child. There needs to be a second adult in this child's life because mom can't be the nice one, the disciplinarian, and everything. Someone else has to play a role. And I just want to remind you, Mr. Lombardi could have played that role, but he chose to completely abandon this child. And now he's asking you, and the only thing he's been doing for the last 9 years since 2012 is asking you to relieve his obligation to the one thing he's been ordered to do, which is pay.
Thank you. Thank you, Mr. Ward. Counsel, you have a minute.
Okay. I would just say that if the court is inclined to award childcare in this case, I would just ask that the court make that award based on the actual amount the mother testifies to have paid. She claims she's paying $15 an hour in cash for her child care provider, and the court awarded $20 per hour. So respectfully, an award in excess of what she's actually paying is not reasonable. We submit it's not reasonable. Also, the mother had a change to her child
Is it reasonable that your client didn't pay amounts that he was ordered to pay, the pendente lite? What's reasonable about that?
So he was found to not have willfully violated his obligation to pay for child care. That was found to be the case by Judge Pearl in her decision. So
has the judgment been satisfied?
The court, that part of the court entered this order for child care, and then it was remanded back to family court for a determination as to an amount of interest, although we submit that there should be no interest because he wasn't found to have willfully violated the order. So that issue is still pending in family court.
Well, did he pay the principal?
He's fully compliant with the court's order.
Has he paid all of his, all that he was in arrears on?
There's a payment plan for the arrears, and he's in compliance with with what the court ordered him to pay for the arrears. The arrears were set at, I think, $1,500 a month, and he's been paying that every month. Yes.
How much were the arrears? Remind me of how much the arrears were.
There's a question as to what the arrears actually are because there were months where the mother had no child care.
What did the court say the arrears were? Not what you think, what the court said.
Right. Well, this is what the court calculated the arrears based on the actual months.
Just give me a number. I just want a number.
Oh, $100,000 or so. I don't know.
That's a good chunk of money. Thank you.
Thank you. Okay. People versus Timothy Buchanan. Ms. Mitter.
Yes, thank you. May it please the court, Alexandra Mitter on behalf of Appellant Timothy Buchanan. Mr. Buchanan's guilty plea was not knowing and voluntary because he received incorrect information about the amount of time he could spend in prison. The court told him that he could serve a maximum of 45 years in prison, and that was simply incorrect. A few months ago in Joseph, this court decided
I'm not sure that's accurate. Did the court actually say 45 years? Because I don't recall that actually being in the transcript, or that he could be sentenced to and get up to 15 years for 3 consecutive terms. What did the court actually say? Did the court use the number 45? Did they say 45?
The court did not explicitly do the math that 15 times 3 was 45, but she made it quite clear that he could receive consecutive sentences on a maximum of 15 years, and that 15 times 3 is in fact 45. So I think having not done the math is not this positive here, because it was quite clear the amount of time that Mr. Buchanan was facing, and that's just the same as a few months ago in Joseph, when this court decided that a plea was not voluntary under the same circumstances as here.
Counsel, Joseph is totally not applicable here. And the reason why is because in that case, the court repeatedly warned the defendant that he would be subject to 45 years. We don't have that here. And also, the defendant in Joseph told the probation that he pleaded guilty because he feared a 45-year prison term. We don't have that here. Joseph is not applicable here.
Well, here we have actually something stronger than Joseph, because Mr. Buchanan affirmed under penalty of perjury that the 45-year sentence he believed he was facing at the time was the reason he pleaded guilty. He was only 42 years old and knew that a 45-year sentence would be in effect a death sentence for him. So he didn't say it offhand to some probation officer where, you know, there were no penalties for lying. He said so under penalty of perjury. And the court here said the minimum is 7 and the maximum is 15 on each of the burglary counts. And he's looking at 3 of them that could all after trial run consecutive, 3 separate incidents. So the court has offered, for purposes of right now only, 9 years concurrent. And
so, counsel, let me ask you this. What evidence was there that he would have rejected the plea offer if he knew about the capping provision? You know, where in the record is it indicated, you know, what evidence do you have that he would reject the offer if he knew about the capping provision?
Sure. I think that there's a number of things. The first is that he had previously turned down a minimum term offer from the prosecution of 7 years. And we also have his statements, which are that he, precisely as in Joseph, that 45 years in prison was a terrifying prospect to someone who hadn't even been alive for 45 years. And he had just reconnected with his family. And so the idea that he could potentially lose at trial, spend the rest of his life in prison after he had just reconnected with his wife and his children and his new grandchild, as opposed to risking trial and getting another decade where he would still have good years left to serve with his to live with his family. You know, that's very strong evidence. And when this court in Joseph was describing the things that should be considered in thinking about whether whether that misinformation impacted a decision to plead guilty, those are all the types of things that this court was identifying. Mr. Buchanan only pleaded guilty after the court repeatedly told him he was facing 3 consecutive 15-year sentences, and no one corrected the record. And, you know, here stronger even than in Joseph, we have trial counsel saying he had no idea about the capping statute. So while there may have been a question in Joseph about whether the defendant could have known about this capping statute, here we have trial counsel affirmatively saying he did not tell Mr. Buchanan about the capping statute. So all Mr. Buchanan knew is that the judge was giving him a 1-day only 9-year offer. And then if he didn't take it, he was looking at 3 consecutive 15-year sentences. And the prosecution's argument here really is that it wasn't misinformation because a 45-year sentence is technically legal. The penal law just, you know, orders docs to reduce that sentence to 20 years. And so it's not really misinformation at all. But in Joseph, that was precisely the argument that this court rejected because it's devoid of common sense. When a judge is telling a defendant what his maximum sentence exposure is, the judge is doing that so that the defendant can weigh that exposure after trial with the plea offer. That's one of the most important considerations that a defendant is making when deciding whether or not to accept a plea offer. And each time here, the trial court drew a direct distinction between the 9 she was offering that day and the 45 he was facing. And Mr. Buchanan had absolutely...
You have time on rebuttal.
Thank you.
Okay. All right. Mr. Kress.
Yes, thank you, Your Honor. Good afternoon. People versus Murray is the controlling decision in this case, not People versus Joseph. Justice Kennedy was absolutely correct. Joseph is just not applicable here. And counsel was just discussing this distinction between a court telling a defendant the amount of time to which he or she could be sentenced versus the amount of time that he or she could serve in prison. And that is a distinction that this court, it appears, has drawn in Murray and in Joseph. And that's the difference.
Did the court say that to the defendant? This is how much time you can be sentenced to, and this is how much time you could be required to serve.
So, Your Honor, never once in this case, not once, did the judge actually say, this is how much time you would spend in prison, this is what you would serve, this is what you would do, nothing like that. What the judge said Oh, I'm sorry, go ahead.
I'm sorry, I interrupted you, pardon me. Did the judge make it clear that that wasn't the time that he would actually be in prison, but only the time that he could be sentenced?
Yeah, so the judge used the phrase, and I'll quote, could be sentenced to up to 15 years on each count. And so specifically use that term. Also use the term get, which I think implies the amount of time to which he would be sentenced. So never once did the court actually express amount of time that he would spend in prison. And I think that's the reason why Murray is controlling, because the court did the exact same thing in that case. And I will also say that turning to the sort of alternative argument here, it would be inconceivable for the defendant to have gone to trial in this case. I mean, the evidence was truly overwhelming. He was caught on surveillance video committing all three of the robberies. And I know counsel points out that while surveillance video was never tested in a hearing or a trial, it was obviously clear enough for a bystander to pick the defendant out of a wanted poster that was created from one of those surveillance videos. And in one of the burglaries, in addition to the video, he was arrested in possession of a package that was stolen.
Counsel, is the only issue whether the defendant would have gone to trial, or is there the additional issue of whether he would have been able to better negotiate his sentence had he been properly informed that while he could be sentenced to X number, he would only actually have to serve another number based on the statute? Wouldn't that information assist him in negotiating a better sentence for himself?
So, Your Honor, yes, I think it could be relevant information to know, but...
So how can, if that is so, that would be relevant information to know, how can then the sentence be said to be knowing, intelligent, and voluntary?
Well, because this court and the Court of Appeals and other courts have held that a defendant doesn't need to know every single piece of relevant information for a guilty plea to be knowing and voluntary.
But is the sentencing parameter one of those things that a defendant doesn't need to know?
The sentencing parameter is, but not the amount of time that you actually would spend in prison.
Are you kidding me? It's more important for him to know what the parameter is than the actual time he's going to serve in a prison cell? I can assure you there is no defendant that agrees with that statement, not one.
Well, Your Honor, let me be clear. We're talking about what the court's obligation is. The court's obligation is to tell the defendant the sentence. The court doesn't have to explain every single calculation that goes into determining when the person's going to be out. Does the court have to talk about, well, you could get this amount of time in good time credit. You could get this amount of time for, time already served. This is your maximum release date. The court doesn't have to do any of that. So no, the judge's responsibility extends to the amount of time the defendant has to be sentenced. To the extent that the defendant wants to know how much time he's going to serve, it's his lawyer's responsibility to tell him that information.
Okay.
And unless the court has any other questions, we'll ask the judgment be affirmed.
Thank you, Mr. Kress. Ms. Mitter, you have a minute.
Thank you.
2 minutes.
To answer the question that Justice Mazzarelli actually posed to counsel for respondents, the court did not make it clear that there was anything that would change the 45-year sentence that Mr. Buchanan was facing. And contrary to Mr. Kress's position, it's not the case that the trial court has to explain every potential permutation of a sentence, but where the court takes it upon itself to explain the maximum exposure that a defendant is facing, it has to provide accurate information. And here, there was nothing in the record to suggest to Mr. Buchanan that 45 years would turn into 20 automatically. And so as a result, he was weighing a 9-year sentence versus a 20-year maximum instead of a 45-year maximum. And that's a significant difference. And so we would ask this court to please reverse the conviction and allow Mr. Buchanan to withdraw his guilty plea, or on the alternative, given the substantial mitigation presented by Mr. Buchanan's traumatic upbringing and substance abuse and mental health issues, which led to the commission of these crimes. We would ask that.
Just one quick question. How do you respond to Mr. Kress's argument that the Murray case is more applicable here? Our decision in Murray is really controlling.
Sure. With all due respect, having handled that case, my office handled Murray, and he's wrong on the facts. In Murray, the defendant argued that he was misadvised by his attorney about the impact of the extreme emotional disturbance defense. And so this court really was dealing with a situation in which the defendant wasn't prejudiced by the misadvice that was at issue there, because that misadvice only went to the extreme emotional disturbance defense and the sentencing implications of successfully prosecuting that defense. And the defense expert in that case said that the extreme emotional disturbance defense had no chance of success in that case. And For what it's worth, in Joseph, the prosecutor made the exact same argument that the evidence was, overwhelming, and that wasn't dispositive to Joseph. And in Joseph, the defense counsel said that he had no defense to the charged burglaries. Yet that was not relevant to this court's determination.
Because I'm looking at Murray, and actually I'm reading from it. In any event, to the extent defendant could be viewed as having received inaccurate information concerning his possible sentence exposure, that factor is not in and of itself dispositive regarding the voluntariness of a plea. Under the totality of circumstances, we conclude that the alleged misinformation could not have influenced defendant's decision to plead guilty. And those circumstances included the strength of the people's case, the numerous counts involving the victims, the weakness of the evidence supporting the affirmative defense, and the reasonableness of the court's promised sentence.
Yes, in and of itself, sentencing misinformation is one of the factors that is considered, and that's black letter law. But that is not what the prosecution is arguing here, which is that this misinformation was effectively not misinformation at all. Thank you.
Thank you. Okay. Perez versus Live Nation.
Good afternoon.
Good afternoon. You have 8 minutes, sir.
May it please the court. My name is Tim Kapowski of Shaw Bounty, appearing on behalf of the defendant Appellate. I apologize for my voice today. I was just discharged last night from the hospital with pneumonia, and I ask that you patiently bear with me. We're asking this court to grant relief from an irrational $102 million verdict, including a new trial based on egregious summation misconduct. In the alternative, we're asking for a remittitor to $6 million for pain and suffering, $5.85 million for future medical expenses, and $1.49 million for future lost earnings. This court has reviewed countless excessive damages verdicts, but here, unlike many others, we have the benefit of knowing why. The jury was inflamed by an improper summation. Starting with the remittitor of the $85 million pain and suffering verdict that was the subject of an anchor, improper anchor, we say, we exhaustively briefed the entirety of this court's and every appellate court's catalog of 5501C brain injury damages jurisprudence, as well as for worse injuries to provide additional context for your honors.
Counselor, this case brings to mind another recent matter that I believe both Justice Kennedy and I presided on, and that's the Hedges case.
I'm about to talk about that.
Which involved traumatic brain injury and a lot of other very serious sequelae that she had. And she's a good deal older, if I recall correctly, than the plaintiff is in this case. And although she was subject to some very severe medical treatment, I don't believe that she had 4 brain surgeries and is due to have another brain surgery.
Yes, Your Honor, I'm going to discuss Hedges in detail in a minute, but just to respond to your question, that's the plaintiff's sole argument in this case, which is the surgeries, which were not all brain surgeries. They're craniectomies and craniotomies, which are slightly different. But let me just say that this court's decision in Hedges
involves going into the skull, doesn't it?
Correct, yes, but I'll explain. This court's decision in Hedges actually puts the lie to plaintiff's argument that surgeries are the sole and exclusive thing that you focus on. It allowed more than all the other surgical cases.
I'm having a hard time hearing you breaking up.
Oh, I'm sorry.
I didn't hear you.
Okay.
You broke up. Sorry.
This court's decision in Hedges put the lie to all of that. It allowed more than all of all the surgical cases that this court has previously ruled on and all the other courts of the state. It focused on the mental and physical deficits from the injury, not just who had the most organic damage, who had the worst diagnostic film, or the number of surgeries. Frankly,
we didn't give Mrs. Hedges enough money.
Well, I know that there's a re-argument motion saying that it should be reduced further, but that would be Mr. Morelli's argument. But all the courts in the state have followed this rule, and I can tell you, plaintiff has not had the most surgeries. It's simply not true. First of all, there are several plaintiffs in the case law who have had craniotomies.
Counsel, I'm hearing you. This is Judge Orange. I'm hearing your arguments, and you can't discount the fact that you're going to go in for brain surgery. I'm not doing that. But the guy's going to go in for another brain surgery, and things can happen in the surgery when you go into surgery, right? So, yes. it's a hard thing to put a dollar figure on. What happens if he doesn't make it through? It goes in for a routine surgery, and next thing you know, it comes out totally, bad.
You're absolutely right. You're absolutely right. But this court and all the other courts of the state have ruled on that principle.
Well, but we also know that this stuff is it's not static in terms of these awards. I mean, right. as we find more and more, or get more and more knowledgeable about brain damage and what happens later on. I mean, the fact of the matter for me is that this individual here, 30 years old at the time, he's not going to be the same person, right? I mean, he's totally different. I mean, he wasn't a drug. He wasn't a drug. He wasn't on. He wasn't like doing bad things before he got injured, right? I mean, from the record here, he seemed to be pretty productive, and he had a goal going somewhere.
Yes, and we can discuss the deficits in a second, but let me just say that Your Honors have ruled on all of this, and there's been cases with far more significant surgeries, including plaintiffs who had not only the skull removed to prevent the swelling, but they've had surgical removal of contused brain tissue from multiple sections of their brain.
We handle another type of case in this court that is so fact specific, attorney discipline cases. There's never exactly one case that's like the other. And when we're trying to figure out precedent for damages, that's the quandary that we're placed in, because there's never any particular person whose injuries, whose age, whose prior experience, whose goals is exactly the same as the case that we have presently in front of us. We always have this issue.
Yes.
So it's something of a balancing that we have to engage in.
Yes.
And we have to really look at each case on its own facts and the impact of the injuries and what the person has endured and what their prospects are, their age, their background. I mean, this individual wasn't a trespasser. He wasn't committing a crime or anything of that nature. He was working.
Right, and none of the other plaintiffs that we're talking about, were committing crimes. They were all working too. Or in the example of Turturro, he was a 12-year-old kid riding a bike. But Turturro, Angamarca, Nunez, Doviak, and Shelley all involve far worse brain surgeries involving far worse sequela than this case. And the courts have ruled, this court and others have ruled on the proper range of compensation for them.
Can I ask you a question, counsel? Can I ask you a question? And that brings up a point, in terms of those dollar awards, those past awards that we're talking about. If you were to advance them and put them into present day dollars today, would those awards be significantly higher?
They would be $500,000 to $1 million higher if you use the record low inflation that we've had in this country for the last 20 years. Yes. Right. So if you take Angamarca, which actually we do have an analogous case from this court that was argued by Brian Isaac a few years back. Angamarca had a worse trauma. He fell further. He fell 20 feet. He actually had portions of his brain removed in the initial surgery from several portions of his brain. He was institutionalized at a residential home, and at the time of trial, he was still getting 6 hours of therapies. And this court approved a $5 million pain and suffering award in that case. So again, what it is in these cases, yes, it's fact specific, but we do have a spot on analogous case, which is Angamarca. He had the same exact marsupialization surgery, which is where they remove a part of the skull to permit sculling. They park it in your abdomen until the swelling goes down and they put it back on. So these surgeries he had that first marsupialization surgery, so did Angamarca. He had subsequent revision surgeries because of infections at the point of the skull. And at the final one he's going to have is the implantation of some titanium mesh to close the residual area that's not covered. Those are the surgeries he had. You have reviewed these cases and you have priced them. And the fact is the statute 5501C requires that the court, under the Donlan case of this court, requires that we do adhere to the sustainable range for these cases. And yes, if you say this award is 10 years old and I want to account for the very low inflation we have in this country, then yeah, maybe it's $500,000 or $1 million.
So that doesn't correspond to medical, the cost of medical care in this country. It
Well,
doesn't
well-
correspond to the low inflation rate, Council.
Well, that, and he got a $10.7
And I
million
both know
future,
that.
he got a $10.7 million future meds award to account for that. We're talking about pain and suffering awards. If you raise pain and suffering awards drastically, which is what Mr. Morelli is asking you to do, instead of incrementally to account for inflation and things like that, then what you're doing is you're raising the cap on everything else, and you're raising the price of these cases on a category of damages that the Court of Appeals has called a legal fiction. All right, the awards for all the future medicals and pain and earnings have gone up drastically since the last 20 or 30 years. But pain and suffering awards are required under the statute to maintain some certitude. It's one way that your honors can stop having to hear me and Brian Isaac argue about the value of a fusion surgery every 2 weeks.
Thank you. On that note, we'll hear you on rebuttal. Okay, Mr. Morelli.
Yes, may it please the court. Good afternoon, your honors. I'm Ben Morelli, and I'll be arguing today for the plaintiff respondent, Mark Perez. I appear today to argue that under 5501C, that the Perez verdict, as reduced by the trial court, does not materially deviate from reasonable compensation. Just 2 months ago, as Judge Mazzarelli just indicated, this court decided its most important brain injury case to date, recognizing the severity of Marion Hedges' injuries. Mark's case is an objectively severe organic brain damage case, which is not only permanent, but progressive. It's very important to understand that in severe traumatic organic brain damage cases, only 20% can be visualized on a CAT scan or an MRI. And that is the category that Mark Perez case falls into. It is substantially more severe traumatic brain injury case than Marion Hedges. Now, let me be clear. I am not here to—
Could you explain why, since your adversary seemed to downplay the extent of this young man's injury and alluded several times to how his brain surgeries weren't really brain surgeries, they weren't as extensive or as severe, etc. Could you please speak to that?
Yes, thank you, Your Honor. These are the injuries that Mark Perez has that Marion Hedges doesn't share. Now, I read the opinion in this case dated January 17th with reference to Marion Hedges, and I read the respondent's brief in Hedges. And Mark Perez has every one of those injuries and the sequelae. These are the injuries Mark Perez has that Marion Hedges does not share. 4 brain surgeries and 1 brain surgery definitely to come. As a matter of fact, the defendants asked for mitigation of damage charge to the jury because he needs the 5th surgery and he was too afraid to have it because he almost died under surgery number 3. He has intractable traumatic epilepsy. It's intractable because he was on 5 or 6 medications that will not control the seizures. And he will need surgery for the epilepsy because it has not abated. Yes, he had marsupialization. Hedges didn't have that. They don't take off your skull and park it in your abdomen. Sounds like a car. No, they actually open up your abdomen, they cut off your skull, they put it in there, and then it takes another surgery to take it out and put it on your back on your skull. That didn't work out for Mark because he wound up with infections that almost killed him. Now he has 2 or 3 times.
Mr. Morelli, Morelli, I think the record is pretty clear about what your client's going to go through and what he's been through and what he goes through. What's your response to the appellant's argument that that we will be increasing the caps, that the caps will be blown off, and in terms of these awards, it's the sky's the limit, and there's a concern about how this is going to affect everything downstream. What's your response to that?
My response is that there is no cap in New York. Now, Mr. Kapowski likes to put 5501C and call it a cap. Actually, it talks about if a verdict does not materially deviate from what's reasonable, it should be affirmed. And then he talks about 4601, and he puts them together as if it's a witch's brew. This court spoke about this just earlier. No two cases are the same. Mark had his injury in 2013. He's been waiting since then for compensation. First, he got a jury award. Then the court heard it. The court sat through this case for almost a month, heard all of the medical experts. We had 6 medical experts in this case, from brain injury expert, psychiatrist, and a neurosurgeon. And the neurosurgeon is talking about Mr. Perez needing epilepsy surgery to remove those parts of his brain that are causing the epilepsy. This is what he has to look forward to in the future. Now, the world is not going to come to an end because Mark Perez gets his just damages in this case. And the problem is that although it's much more severe than Hedges, Hedges should not be a ceiling to this case. There should be no case that's a ceiling. I understand that we look at them as a guide, but they're not a cap. There is no such thing. If the legislature wanted to put a cap on damages, they would have done it, but they didn't do it. Mark Perez has permanent bleeding in his brain, and that's not usual. Usually, when you have an injury like this, you have bleeding around the brain, inside the skull, but not inside the brain. This is permanent. He has profound cognitive deficits. He's going downhill. And unlike Hedges, who was 17 years older than he was at the time of the accident, he never had an adult life. She was able to get married, have children, watch them grow, and have meaningful employment. Mark lost his fiancée because of this accident, will never have children, never have gainful employment or meaningful employment, and he has a 2 to 3 times chance of profound dementia and or Parkinson's disease. This is what he's looking forward to. This is a fallacy that Mark Perez's case is not as severe as all these other cases. Every single case that was cited in the brief in Hedges.
Mr. Morelli, Mr. Morelli, quickly now, I have one last question. Sure. The appellate counsel is trying to moor your case with all the prior cases where this court made awards of $5 million, $2 million, $3 million, and I was asking about how those awards in the older, like several years ago, and inflation, yes. And he's saying that your case should be in line with those cases. What's your response to that?
Well, this court and 2 members of the bench today were on the Hedges case. They answered that because they actually, when they reduced the award in Hedges, they cited Totoro. And they also, the court spoke to this by saying that Hedges was much more severe. Hedges didn't have any surgeries, okay? And although Hedges almost died as a result of this accident, Mark Perez had to be airlifted to the hospital for emergency surgery. And the surgical team told his family that he had a 10% chance of survival. His mother has to cross the street with him now because he doesn't look out for cars, because he doesn't get it. and he's getting worse every day. He didn't have his 5th surgery because he's so afraid of getting worse. Now, the neurosurgeon who's the head of epilepsy surgery at Cornell Weill has testified in this case that he will be doing surgery on Mark. What he has to do is find out which areas of the brain are causing the epilepsy. We have to understand that none of these cases have this traumatic epilepsy. When Mark tried to be normal, he went to a yoga class. And during the yoga class, he had a grand mal seizure where he defecated himself and urinated himself, and he had to be rushed to the hospital. That's what Mark Perez's life is. It's such a more substantial case than any of the cases that ever came before this court. And the reason that I'm talking now.
Counsel, you have 30 seconds.
Oh, God, that's not a lot. Anyway, so what I want to say in closing is that we submitted photographs to your honors. I'd ask you to look at them. And we also have a very short video showing Mark having a partial epileptic seizure, a grand mal seizure, of which he's had more than a dozen already as of the time of trial. And he has had 100 auras, which are also epileptic seizures. Now, obviously, after I finish, my adversary has rebuttal, and he's going to say what a great recovery Mark has made. And he did make a great recovery. He's alive, okay? But none of these cases have anything like that. Mark has encephalomalacia, which means that he's missing parts of his brain. It's called brain rot or missing brain. And he has a gliosis, which is scarring all around that area. And the brain injury doctor testified that the reason that happened is because of the stretching and twisting of the brain. And I ask your honors to look at this case for what it is specifically, and please don't tie it to any particular case because it wouldn't be fair to Mark. Thank you.
Thank you.
All right.
Okay,
There's a
Counsel,
lot to
you have
respond
2
to
minutes.
here. The cap that we've talked about has been set by appellate precedent. So Mr. Morelli's asking you to raise this injury above those of paraplegics like Ruby, Miraglia, Bissell, that have awards reduced to 10. That's not rational if he wants to have a higher award for our worst injured plaintiff. And it's also not fair to those plaintiffs who have their awards reduced. There's no way you can justify this award in comparison with Barnhart, a 23-year-old quadriplegic who had her award reduced to 10 million, 12 million, I'm sorry. And the Engamarka case, which again, he's not discussed, Engamarka is worse, and your honor's own decision states it on the front of the decision. The idea that a plaintiff has seizures, there's a half a dozen of these brain injury plaintiffs that your honors have reviewed who have had seizures. Turturro was a 12-year-old who had his head broken up on the pavement with brain coming out of it. He's 10 times worse, and his award was reduced to 10, and his future meds were reduced to 7. Mrs. Hedges is far worse. She had a 60-pound shopping cart fall on her head from 70 feet. She was clinically dead at the accident scene in full cardiac arrest for 2 minutes and turned purple before her respiration was restored. Her MRIs revealed she had vastly worse injuries to her brain than here. She had near constant double vision, dizziness. She can only walk with a cane. She has memory loss, wears diapers for fecal incontinence, not just one instance, but daily and weekly. Her treating physicians, and her case was again put on entirely by treating physicians, not experts, because all the treaters in this case didn't agree with what the experts were saying. And I'll quote to you from the treating psychologist. She said his performance on the test of memory malingering, which is a routine diagnostic test around the industry, suggests that although Mr. Perez may have cognitive abilities that have been compromised by his accident, it's unclear as to how much he may have exaggerated or amplified their presentation. This is his treater, and this is why there were no treaters in this case, Your Honors. The case was put on by experts. None of the awards in the anywhere from $5 to $12 million range in this court's history have ever been put on exclusively by treaters to the exclusion of experts. I mean, flip that. But what I'm saying is, all the neurologists that treated this gentleman for the last 5 years or 10 years, they found that his function was mostly restored, normal, intact cognitive memory, attention, language, and gait functioning following the trauma. They have direct histories from the plaintiff and his father that directly disconnect with their trial testimonies. And I just want to tie one other thing. This case is important. It's why you have 24 amici curiae submitting, including the not-for-profit New York Association for Affordable Housing, which protects all of our most disadvantaged citizens to keep a roof over their heads. This is not something where he can just dismiss all these cases. The facts of these cases, which we laid out and which he ignored in his brief, the facts of these cases are comparable or worse than this case. So he can say it as much as he wants, but the other part is the summation in this case was outrageous. And Your Honors ordered a new trial in an almost identical situation for a plaintiff 3 years ago in Smith v. Rudolph. He went into the motivations of the defense for defending themselves, and he attacked all the evidence that I just mentioned, the treating neurologist, the testing. He attacked it on summation and told the jury that they should be insulted 8 times. He told them that Live Nation was looking for a discount.
Thank you. You're out of
20
time.
times. Your Honor, I ask you for the amicus and for my client to please look at this very closely because this is an important case.
Thank you so much.
Thank you.
WVH Housing versus Brooklyn Insulation. Ms. Ayala, you have 3 minutes.
Thank you. May it please the court. My name is Yolanda Ayala, and I represent the defendant appellant, Brooklyn Insulation and Soundproofing. It's the defendant's contention that the trial court erred in denying its motion to strike the plaintiff's note of issue. In the first place, the lower court erroneously applied the unusual circumstances and substantial prejudice standard articulated in 22 NYCRR 202.21D rather than the less demanding standard provided in 202.21E. Under the latter standard, the defendant was only required to show that this case was not ready for trial. Here, the defendant easily met this burden since the plaintiff conceded it had not yet provided complete responses to the defendant's post-deposition demands.
Counsel, post-deposition demands are routinely provided in due course after note of issue on a regular basis in courts all over this state. Certainly it happened in the courts that I came from. So that really is not as huge a deal in my mind.
Well, Your Honor, there was also, additional depositions of the plaintiffs that the plaintiff was aware of was requested during those depositions.
Right. Again, these are all last minute items. You guys were under a really tight discovery order in light of all of the delays that had been going on in this case. Isn't that right? The judge ordered a really tight schedule for the parties here to complete their discovery. Seemed like the court was a bit fed up with the game playing between both sides and gave a very tight discovery schedule. So there were some things that you wanted to follow up on after depositions. The court is not entitled to say, fine, you can follow up on that, but the case is not, I'm not taking it off the calendar. It's going forward.
Well, I think, Your Honor, again, the court used the wrong standard. All that we were required to show was that there was additional discovery that was needed. She said we needed to show substantial prejudice and unusual circumstance, and that's simply not the standard that she should have been applying. Also, there was a status conference that was scheduled and unfortunately was canceled due to COVID. So, the defendants had a reasonable belief that had that conference gone forward, additional modifications could have been made to that tight schedule that you mentioned, but we were denied that opportunity. Turning now to the second order, it's our position that the denial of the defendant's request for leave to file a second amended answer was also erroneous, since the defendants were only seeking to correct typographical errors.
Oh, no, those weren't just typographical errors. Those went to the heart of some of the issues in the case.
Right, Your
And
Honor.
it would have inured to prejudice to the other side.
But this was not a situation, Your Honor, that we were suddenly presenting a new defense or a new theory or a new counterclaim or anything like that in the case.
No, things that you had admitted you are now denying. That's not a little thing.
Well, what happened was there was a complaint. There was an answer where everything was pretty much denied. There was then an amended complaint, and then prior counsel, that amended complaint added 5 new paragraphs. Due to a clerical error, things were admitted that were previously denied. So it wasn't that we had, admitted it and then tried to turn around and deny it. We had denied it initially, mistakenly admitted it in the amended, and sought to do the second amended to reinforce the denials that were there initially. So it's our position that, in the cases we cite in our brief, show this is a mere draftsmanship issue as opposed to changing of legal theories. I would also point out, Your Honors, that the plaintiff never claimed prejudice. All he claimed was we were supposed to submit an affidavit of a person with knowledge. We did submit an affidavit of a person with knowledge. That was the prior counsel who accidentally changed the initial denials to admissions.
Okay.
If there's no other questions, I'll rest on my brief.
Thank you so much, Ms. Ayala.
Thank you.
Atco Footwear Holdings LLC versus KBG LLC. Mr. Catterson, you have 6 minutes.
Thank you very much, Judge. And of course, thank you for granting oral argument in this case. I thank the entire bench for that. James M. Catterson for Arnold and Porter K. Scholler on behalf of plaintiffs Atco. Every judge on this panel is familiar with the standard on the 3211 motion. The court is required to accept all the facts alleged in the complaint as true, accord the plaintiff every favorable inference on those facts, and only determine whether any of the facts as alleged fit into any cognizable legal theory. Unfortunately, the motion court ignored the standard completely and violated every prong of the standard. When the court held that because the plaintiff did not require an audit under 3A4 of the management agreement, they essentially waived all rights to be paid under the agreement. This court has articulated the standard for waiver, and you all know it by heart. It's the plaintiff must knowingly, voluntarily, and intentionally abandon a contractual right. Or as Judge Mazzarelli in Echo Star, you held that there must be a clear manifestation of an intent to relinquish a contractual protection. In Echo Star, Judge, you may recall the case. The plaintiff had a choice to allow late payments under the contract, but it had a right to collect interest under the contract, regardless of whether or not it waived the late payments. Here, my client had a choice to audit every year versus an unquestioned right to be paid on a calculation of net gross profits under Section 3A1 and 3A through 3A3 of the management agreement. Now, my adversary will tell you that courts regularly dismiss claims based on this type of contractual procedure. If you'll indulge me for just a minute, Judge, every case cited by my adversary does not hold that. And it starts with C-modes. It's a 1955 Court of Appeals case. First of all, it's a summary judgment motion. It's not a motion to dismiss. Second of all, the defendant has gone out of his way to avoid mentioning the first sentence of the first operative paragraph of the Court of Appeals decision, where it says, Judge Desmond writing for unanimous court, the breach of contract claim is not the subject of the appeal. So the single most important claim in the case here is breach of contract. It wasn't the subject of C-modes. But most importantly, in C-modes, the operative agreement said that the financial statements were, and I'm quoting, deemed conclusive and binding, close quote, unless objected to within 10 days, which is similar, Justice Manzanet-Daniels, to your holding in Ann Young. It's a 2019 decision of this court. In that case, the financial instrument said that objections must be made within 30 days or waived. My adversary also cited the LPS Enterprises. It's a Fourth Department 1999 case. an express waiver after 2 years, and the contract documents were considered final and conclusive. The last case cited, which bears special mention here, Judge, it's New York Foundling Hospital. It's a 2008 Third Department case. It's in my adversary's brief. It is an egregious citation. First of all, it's an Article 78 on a full record. Unlike summary judgment in LPS or summary judgment in C mode, it's actually a full Article 78 record. In that case, there was a dispute over 2 years of Medicaid reimbursements. It's positively Dickensian, I admit it, but they audited those 2 years for 10 years. 10 years of audits. It's all in the record in the Article 78. They eventually resolved the case through a stipulation of settlement. The only thing Foundling Hospital stands for is the proposition that when you settle a case, you can't undo the stipulation of settlement. It has nothing to do with courts regularly dismissing claims on this type of contractual procedure. There is no case that stands for that proposition cited in my adversary's brief, nor did Justice Sherwood rely on any. Where does that leave me? Even if this court were to accept the waiver argument on a motion to dismiss, this court's case, Justice Manzanet Daniels, Justice Mazzarelli, you both sat on TIAA Global in 2015. In that case, this court rejected the question of waiver because the claimed waiver was before the plaintiff alleges it knew the full extent of the defects in the building. Why is that important? It's uncontested on this record. It's wholly uncontested on this record that ATSCO never knew the full extent or had any real insight into the calculation of management fees under 3A3 of the management agreement until after the litigation started.
Counsel, but what about the argument that they had no knowledge because they chose to give up their right to the audit, and hence they thus waived that as an issue?
Well, Judge, waiver, as we all know, it has to be knowing, voluntary, and intentional relinquishment of the right to be paid under the contract. Like all of those other cases that I just went through and that are cited in our brief, by the way, virtually all of them are summary judgment. I will acknowledge that we may have given up our right to audit. There's no question about it. It doesn't mean we gave up our right to be paid.
What was the purpose of the audit? Was it not in order to determine what the proper amount to be paid was?
Yes, Judge. Had they wanted those audits to be conclusive and binding, which is what the Court of Appeals held in C modes, what you held in An Young, what the Third Department and the Fourth Department all held. If they wanted it to be conclusive and binding, they could have written it that way, and they didn't. It's a paragraph and a half, Judge. I commit it to your reading. If you haven't read the paragraph exactly in the record, it's R49, it's 3A4. Nowhere in there does it say that the audits are conclusive and binding. Had they wanted it to be a bar, they could have written it that way. They didn't. Added to that, on the waiver question, it's black letter law in this department. At least it wasn't the case that you sat on, Justice Manzanet Daniels. I hate to keep referring to you specifically, but you're there long enough. This is what happens. It's just a fact of life. And Justice Mazzarelli, I see that your name is on half the cases as well. Art and Fashion Group, it's 2014. It's black letter law in this department that factual affidavits cannot be considered on a 3211A1 motion to dismiss on documentary evidence. Black letter law. So Justice Sherwood should have disregarded the Mizrahi affidavit completely because that's the law in this department. And so if you just go to the handful of emails, which are uncontested in this record, were dictated by Max Mizrahi, the principal of the defendant, not one of them mentions anything other than the audit right under 3A4. Not one of them mentions we're giving up our right to a calculation. Not one of them mentions we're not going to get paid under the agreement. Not one of them. And we know, because again, this court's decision in Kulchin in 2018, 4-1 decision affirmed by the Court of Appeals unanimously, only where the documentary evidence utterly refutes plaintiff's factual allegations, conclusively establishing a defense as a matter of law, and it's the defendant's burden. And I submit to you, Judge, that unless they wrote the agreement that they were supposed to be conclusive and binding, those emails don't mean anything.
Okay,
Where's
you
that
have 2 minutes on rebuttal. and we'll hear you then, okay?
Thank you, Judge.
All right, Mr. Sherwin, you have 6 minutes.
Thank you, Your Honor. Good afternoon. May it please the court, I'm Peter Sherwin of Proskauer Rose for Defendant Appellee KBG. Now, ASCO's claim for even more incentive fees is barred as for the first 4 or 5 years because of its signed writings for each of those years. Therein, it did 3 things.
Can we go back to the waiver argument? As I read section 3A4, there is no waiver language in any of these sections. It talks about the right to receive a computation statement, has a right to once in a 12-month period to look at, examine the records and books, etc. But nowhere does it have any explicit language that failure to do so constitutes a waiver to appropriate payment under the contract, which I believe is what Mr. Catterson is arguing. Could you speak to that, please?
Certainly, Your Honor. 3 things. 1, first and foremost, ASCO expressly agreed to the correctness of these computation statements. Each and every year, it expressly agreed to them, and that is in the record, and Mr. Catterson ignored that throughout his entire 6 minutes.
And do I have the quote? With regard to that, just since you've touched that, am I correct that the statements in those emails was that they were giving up our right to audit for those years? Are you saying that giving up your right to audit is equal to giving up your right to proper payment under the contract?
I'm saying both things, Your Honor. First of all, just to correct on the record factually, they did 2 things in each of those statements. 1, they definitely did say we are giving up our right to audit, which contractually was the right to verify the correctness of the statement and the determination of the proper incentive fee amount. So they did expressly, repeatedly do that. But I want to make very clear, they did a second thing, Your Honor. In addition, they affirmatively said, we agree. I quote, we agree with the computation statements. So they didn't just waive their right to audit to verify the correctness and determine the proper amount. They expressly agreed to them. So that is a fundamental point that bars all of their claims, and Justice Sherwood relied upon that below, and it's throughout these briefs.
Are you saying that under under this contract, they were required under Section 3A5 that if there was a dispute, they had to state so in order to preserve it?
I am so saying, Your Honor. That's exactly right, because 3A4 and 3A5 set out an entire process. It says, 1, by April 30th, the computation statement has to be prepared by KBG. Then in the second paragraph of 3A4, it says ASCO then has the right to review the books to verify that computation statement and determine the correct incentive fee allocation. And then in the very next paragraph, 5, it says if there's an amount owed, then ASCO has to pay that by April 30th. But it then goes on and expressly says if there is a dispute, KBG pays the undisputed amount, and then it goes on, and this is the critical language, it says that ASCO can accept that without a waiver of the dispute or objection. If you accept ASCO's position, which Justice Sherwood rejected, then that whole language would become superfluous, because then there would never be any waiver by acceptance of this amount of any dispute or and again, I need to emphasize it more.
In the same way, counsel, in the same way that statement, that acceptance of such payment shall not constitute waiver of the objection, right? Why wasn't that same type of language added to 3A4 that if you don't examine the books and records and don't object, that's a waiver? Isn't that language that would have made it certainly more clear and unambiguous that that is what was intended?
So, Your Honor, in every litigation I've done for the last 25 years, I would have wished that the transactional lawyers had said something more express. That doesn't mean that it's not the case. They were very express here, Your Honor, in 3A4. It said that the purpose of the audit was to verify the calculations
Counsel,
in the
this is Judge Owing. I just got to ask, putting all this aside, the thing that strikes me is that the simple statement, "we agree," came out. So however we want to describe these documents, what else is your client going to do if someone says we agree? They're not going to go back and say, "Are you sure that you agree? Are you 100% sure? Do you want to think about?" I mean, what else is there to do? Correct? I mean, that's it.
Exactly right, which is why I don't have a perfect case for you. I wish I did, but I've never had a situation where the other side expressly agrees, says it in writing, signs it every year for 4 years, including the retroactively, and then decides to sue for more. I mean, what kind of chutzpah is that?
That's a good way of ending the argument, I guess.
Thank you.
Thank you, Your Honors.
Mr. Catterson, you have 2 minutes.
Oh, you're on mute.
You're on mute.
I knew I'd forget that sooner or later. On precisely the question of "we agree," and on precisely the issue of chutzpah, a fine Gaelic word. The 2017 statement, by 2017, my clients were deeply concerned about the calculations that KBG was doing. So much so that they called it into question for the first time. The 2017 financial statements have now been issued 4 times. Each time they retract it. They issue a statement, we complain, they retract it. They issue a statement, we complain, they retract it. There is no question, and by the way, they don't deny anywhere in this case that they failed to comply with the net profit calculation required under 3A3. They just don't deny it. So by 2017, we were aware that there was a huge problem with how KBG was calculating it, because we knew that gross revenues were up 3 or 4 times, and yet net gross profits, at least the distribution to us, never changed. Even though the company was making money hand over fist, the calculations never changed with regard to my clients. Cushman against Wakefield, Justice Owing, you sat on that case along with Justice Manzanet. In that case, the defense was account stated. And I don't have time to get into the very strange reverse account stated point. It's briefed in our papers. There's no case on record that stands for that proposition. Just like there's no case on record where final and conclusive is not included, and yet the audit provision is enforced to preclude a claim. There is no case on record that says that. But in Cushman against Wakefield, this court wrote that account stated, even when pleaded as a defense or proved at trial, is not conclusive as a settlement of the case if mistake or other equitable considerations are shown to impeach it. So not only am I entitled to not have my case dismissed on a mere motion to dismiss, even if that theory of Mr. Sherwin's is pleaded at trial and proven at trial, I'm allowed to impeach it. And I'm allowed to impeach it after I get discovery in this case. I'm allowed to impeach it with evidence that showed that they cheated my clients madly from day one. Thank you very much for your time, Judge.
Thank you. Century Lane Partners, the third LP versus Nature's Bounty.
Good afternoon, Your Honor.
Good afternoon. You have 5 minutes.
Thank you. Your Honors, the lower court erred.
Counsel, we have feedback on your line. So do you have an additional device that is also open to this proceeding? Because we're getting feedback and it's going to be really hard to understand you.
I don't. I lowered the volume a little bit. Did that help?
That's good.
Okay, let's try that.
Okay. The lower court erred in 2 fundamental ways. The first was by holding that appellant's claims are barred by a limited release that on its face does not apply to respondents' pre-closing misrepresentations. The release at issue here specifically covers claims relating to lost sales in the supply agreement. Lost sales is defined as a measure of damages. It's the difference between the actual service levels that were achieved and the service levels that were required. So in other words, the limited release only bars claims relating to this specific measure of damages, which arise from respondents' post-closing breach of the supply agreement's service level requirements. The claim here does not seek to recover
Counsel,
lost
this
sales.
is Justice Kennedy, and I'm not sure that that's accurate. This is not a limited release. Rather, it's broadly worded because it deals with the lost sales and the in the supply agreement, and also charges invoice related to the supply agreement, contract and tort.
Your Honor, that is correct, but it is a limited release in the sense that it begins by talking about a release of all claims in contract or tort, but it only releases claims relating to specifically enumerated topics. And the only one relevant here is subtopic 1, which is lost sales. So it is a limited release in that sense. It is not a general release of all claims. Here, our complaint does not seek to recover lost sales. We don't assert a claim for breach of contract. We don't assert claims arising from any post-closing conduct. And so the limited release on its face does not apply here, where the claim is one for fraud based on respondents' pre-closing misrepresentations to appellants, and where it seeks classic fraud damages, which is the return of appellants' investment made in reliance.
The problem you have here is that the agreements are replete with disclaimers with regard to representations, and that you can only rely on that which is embodied in any ultimate agreement. You cannot assert damage based on any statements made by anyone for any purpose at any time.
So I have to comment that these are probably the broadest disclaimers that I have ever seen.
Your Honor, that brings me to the second way in which the lower court erred. New York law.
You haven't answered my question.
I believe I'm getting to it. The disclaimer is inapplicable here because the information that underlies our claim is information that is uniquely within the respondent's possession. It is their intent not to perform. And New York law on this point is crystal clear that a disclaimer, regardless of whether it is specific or not, cannot bar a claim for fraud when it concerns matters that are peculiarly within the respondent's knowledge.
What case have we upheld a claim for future acts? Fraud based on an intent to defraud based on a claim for future acts.
Your Honor, there are several
cases. What I believe you're saying, right? Or have I misunderstood you?
You have not misunderstood. It's the issue is that regardless of the specific context, when a matter is peculiarly within a respondent's knowledge.
Our jurisprudence, I have sat on multitude cases where we dismiss precisely these kind of allegations. You cannot sue for he never intended to fulfill this part of the contract. That is not a legitimate action. Under our jurisprudence.
The representation here is not a promise of future performance. The misrepresentation was the present statement of intent, which this court and the Court of Appeals has repeatedly held can support a claim of fraud. Here, the respondent specifically said pre-closing that they intended and that they would eliminate this policy of prioritizing wholesale customers first, and that they would correct the supply chain issues. And our complaint alleges that they made that promise with a preconceived and undisclosed intent not to perform, which is black letter promissory fraud. And to your specific question about whether this court has upheld disclaimers in that context, it has. There's the case basis yield that we cite in our brief, which discussed whether a disclaimer can apply where the withheld fact was something within the defendant's peculiar knowledge. And in fact, it was their knowledge of certain facts relating to some securities that it was selling. And there's a Southern District case that applied that and applied several of this court's rulings that likewise found that a defendant's intent to commit fraud is something that is peculiarly within their knowledge, and it found that a disclaimer did not apply.
Thank you. You'll have a minute on rebuttal. Ms. Thompson, you have 5 minutes.
Good afternoon, Your Honors. May it please the court, Letitia Thompson from Morrison Cohen for the respondents Nature's Bounty Co. and NBTY Manufacturing LLC. I think the panel has hit the nail on the head with this case, that there are numerous disclaimers, numerous releases. If the respondents in this case couldn't disclaim their reliance, there is not a defendant or respondent in the country that could. At every single instance, these sophisticated investors promised the respondents in this case that they would not rely on statements made by individuals. At the beginning of this entire relationship, these sophisticated private equity companies had to sign a confidentiality agreement. The confidentiality and non-disclosure agreement specifically said that in order to get the preliminary marketing materials, the plaintiffs in this case would agree not to respond and not to rely on them and to do their own due diligence. It's the exact same kind of representation that this court relied on in RK Film Financing versus Kavanaugh, which procedurally was a very similar case, where you started out with a investor who underlying company went into bankruptcy. All of the claims that could have been brought by the actual counterparty were released. And the investing body tried to bring these claims, which were no longer viable. Every single representation that the appellant in this case is trying to rely on were things they promised they would not rely on. They specifically, in both a confidentiality agreement to get the marketing materials, promised they would not rely on the marketing materials. Once they actually had the marketing materials in hand, which incidentally doesn't include this claim that NBTY will discontinue a wholesale prioritization policy. Interestingly enough, that phrase is nowhere in the complaint and has only made it into appellant's briefing. If you look at the record, which actually includes the excerpt from the marketing material, it's not in there. What it says, it discloses a policy where third parties were prioritized. And it says what NBTY will do is they will transition to third-party providers. But
Ms. Thompson, if I may, this is Justice Kennedy. Now, the appellant did have knowledge that there were some concerns regarding supply levels, and that was pre-closing. They knew that.
Of course they knew that. And that's why they negotiated for a supply agreement, which specifically said, if we don't meet these the supply requirements as we historically have, if we don't, we will pay you damages pursuant to the supply agreement. So they had knowledge of it. They disclaimed reliance on it. When they got the marketing material that disclosed the historical failure to provide adequate supply, they again took it with a disclaimer that said, I won't rely on anything. They went on to negotiate an acquisition agreement that said, oh, by the way, I'm not going to rely on anything other than what's in this contract, including the contemporaneous supply agreement. And then when the relationship went on and NBTY, unsurprisingly, was unable to meet the full 95% supply requirements, as it had never done historically, a settlement agreement was entered and a release on all contracts and tort claims related to that failure to meet the supply requirement was executed. This is literally a case where every single form of disclaimer, reliance, promise not to rely on anything outside of the contract, and then a release for any related contract or tort claims was executed. I mean, in all of my years of practice, in all of the cases, even the cases cited by the appellant, there was never this series of continuous representations not to rely on something and then to claim to have been misled. What makes this difficult?
Thank you, Ms. Thompson. Okay, you have 1 minute.
Thank you. The disclaimers here cannot, as a matter of law, disclaim matters that are within the respondent's peculiar knowledge. And what all of respondent's arguments ignore is that the fraud claim here is based on respondent's pre-closing misrepresentation of their intent to eliminate this policy and to correct the supply chain issues. The fact that she admits that it's unsurprising that the respondents did not meet those levels because they never did, in fact, is only evidence that they never intended to because they knew that they couldn't. That only further supports our claim.
Not necessarily. I mean, I think that, your client enters into an agreement with someone who had never reached that level of supply. Clearly, there was some risk there.
Your Honor, but the issue here is whether they had a preconceived intent not to perform.
And again, I tell you that under New York State law, that is not a recognizable action. And you haven't given me a case that says that it is.
Your Honor, there are several cases from the Court of Appeals. We've cited Graubard, this court's decision in Ladzinski. There's the Court of Appeals decision in Deerfield. All of those say that a misrepresentation made with a present and with an undisclosed intention not to perform that existed at that time is a misrepresentation of fact that does support a claim for fraud.
Okay, thank you.
Thank you.
Davis versus Port and Cerberus Capital Management LLP, and I should have said that in reverse. Mr. Brenner, you have 7 minutes.
Thank you, Your Honor. May it please the court, Eric Brenner on behalf of plaintiff appellant Paul Davis. Our briefing sets out in great detail, Your Honor, the facts and the internal documents we have at this stage of the case that show why we believe there's a reasonable inference of the kind of actionable wrongdoing that the second amended complaint asserts. We don't dispute that the trial court engaged with many of these facts and with many of these documents to a certain degree. The problem, however, and the reversible error is that on the face of the lower court's opinion, the trial court weighed the evidence rather than applying the proper standard on a motion to dismiss, which Mr. Catterson helpfully explained already in another case involving Justice Sherwood. There are two glaring examples I'd like to point to, Your Honors. First, critical question in this case is why did Scottish Re agree to pay Cerberus, a controlling shareholder, $455 million on these so-called Orkney notes, thereby permitting Cerberus to make windfall profits of $150 million. We say, in short, it's because of wrongful conduct, and I'm happy to explain all the details. The trial court's response was to say, quote, "It is plausible to infer that actually Scottish Re pressed ahead with the Orkney transaction based on the need to complete a reinsurance transaction with Hanover Re as opposed to pressure from Cerberus. It is plausible to infer this defense." We do not agree that this is remotely plausible on the facts that are in the record at this stage. But someday, after we get Cerberus's documents, after we take depositions, a jury can sort out if I'm right or if I'm wrong, and whether this actually is a reasonable defense. But for now, Your Honors, you can't throw out a case on the pleadings by weighing partial evidence and deciding that a potential defense is plausible. That literally turns the standard at a 3211 motion on its head. The question is whether or not our claims are plausible based upon, after drawing all the reasonable inferences in our favor and accepting our facts as true, not trying to conclude whether or not defendant's theory of the case is plausible. Second glaring example, Your Honor, this goes to the conduct of Mr. James Chapman, who you might remember was the head of the special committee that was created because the Orkney transaction created all sorts of conflicts because Cerberus was on both sides of the transaction, selling $700 million in face value notes to Scottish Ray, even though it was at the same time an owner of Scottish Ray. And so one of the questions that is central to this case and to our claims is whether Chapman, who was the head of the special committee and was supposed to ensure fairness in this transaction and that Cerberus didn't get paid too much, central question is, did he do his job, including taking into account the fact that he had no less than 9 affiliations with Cerberus, serving on the boards of various Cerberus portfolio companies, and was not independent at all. We say this was completely improper that he had this role in the first place. And we also say, parsing the various emails, as you've seen in our briefs, that he didn't do what he was supposed to do, and in fact, ultimately threw up his hands and said he didn't care how much Cerberus got. He was, quote, agnostic on this point. Here's what the trial court found on this central issue. Trial court said, quote, for the most part, Chapman took care to scrutinize the Orkney unwind because it would likely benefit Cerberus. For the most part. Again, just like the finding about what was plausible about what was driving the overall transaction, I do not agree that it was, that even for the most part, Chapman was doing what he was supposed to do. But even, again, taking at face value Justice Sherwood's findings, you can't dismiss claims of wrongdoing on the pleadings based upon partial evidence before discovery based on the finding that for the most part, it seems like everything was on the up and up. The evidence here, again, don't need to go through all the emails, but if you've got a conflicted transaction like this, and again, remember the baseline, the emails show it was, quote, a raging statement of the obvious that this was a related party transaction with the potential to cause problems. Corporate Law 101, when you've got conflicted transaction like this, you got to look at the procedural aspects of what goes on, and you've got to look at the substantive aspects of what's going on. There is ample reason to infer that the Orkney transaction fails both counts badly. Procedurally, right at the beginning of the transaction, this is in a chronology they submitted below, not us. Cerberus promised to put Chinese walls in place to protect against the improper use of confidential Scottish Re strategy information. And then what do we see in the chronology? They say they're going to do this on March 6th, I think it is. March 15th, they glaringly ignore it and get chastised by Scottish Re's general counsel. Complete indifference to procedural protections. Talked about the fact that they created a special committee. That's good. That's what's supposed to happen. But then they put Chapman in charge, even though he's completely tangled up with Cerberus, non-independent at all. And then what is the point of the special committee? As I said, the point is to ensure an independent review, untainted by influence by the conflicted parties, meaning Cerberus should not be involved in deciding whether Cerberus is getting the right amount of money. That's for people who don't have anything to do with Cerberus, who are insulated from Cerberus's influence. But what you see in the emails is when this transaction is hanging in the balance and the special committee is calling into question whether this transaction benefits anybody but Cerberus and what on earth it does for Scottish Re itself, Jonathan Bloomer, who's one of the most senior executives at Cerberus, inserts himself into the special committee review process, begins pushing Chapman to ensure that Cerberus gets the price that Cerberus wants. And again, remember, Chapman has all these ties with Cerberus already. And then sure enough, Chapman decides he doesn't care what the price is. Now, again, we go through in our brief all the reasons that we think what Bloomer did was wrong, but you don't even need to get to that level of detail. Bloomer never should have been. Yes, I'm sorry.
You're out of time. You have some time on rebuttal.
Thank you.
Okay, thank you. All right, Mr. Gladstein, I believe you are up next. You have 5 minutes.
Thank you, Your Honors, and may it please the court. My name is Andrew Gladstein. I represent Cerberus Capital Management. Your Honor, This is the third time the Supreme Court has dismissed appellant's claims against Cerberus relating to the Orkney transaction. Both of those prior dismissals were unanimously upheld by this court. The second amended complaint fares no better. Now, appellant challenges the dismissal of 4 of the 5 claims against Cerberus, and as you just heard, he primarily argues that the court should have drawn inferences in his favor from a handful of documents that were submitted with plaintiff's opposition motion. And that position is entirely without merit. But I want to first, from the outset, quickly address something that Mr. Brenner ignored, which is the predicate for all of these claims in the first place. And that is a fully empowered special committee of independent directors approved a payment to unaffiliated holders of the Orkney notes of 90 cents on the dollar in the exact same transaction and at the exact same time. The company approved a payment to the Cerberus affiliate of 65 cents on the dollar. Appellant does not challenge the 90 cents that was paid to the unaffiliated note holders who held some 150 million in notes. He only challenges the 65 cents that was paid to the Cerberus affiliate. And Your Honor, on those facts, there is no constitution. But turning to the Supreme Court's basis for the dismissal, it was sound. And I think what's going on here is appellant is cherry picking a couple of quotes from the decision that address some of the documents and ignoring the places where the court says repeatedly that the factual allegations were insufficient. The dismissal of the breach of fiduciary duty claim was correct because, as this court has already held, majority shareholders like Cerberus do not owe fiduciary duties under Cayman law. The unlawful act conspiracy and dishonest assistance claims depend on allegations of collective conduct between the two, the directors on the one hand and Cerberus on the other. And here there is none, as the court rightfully found. And finally, the breach of confidence claim failed to identify any information that was confidential or that was purportedly misused. But I want to turn to a separate basis for dismissal, which the court did not reach because it dismissed the claims.
Counsel, you represent Cerberus, right?
Correct.
And we're applying Cayman Islands law, is that correct?
That's correct, Your Honor.
How is it that the claim is not sufficiently stated, given the entire record, for at least at this stage? This is the pleading stage, for at least the reasonable inference that your client assisted, helped, aided in, while not having its own fiduciary duty to breach, but aided in the other party's breach of fiduciary duty? Because,
Your Honor, there are no allegations of that assistance work. All there are is basically this very basic argument that the directors should have demanded more from Cerberus. They should have negotiated harder. They should have got a better price, even though they were willing to pay independent, unaffiliated note holders a substantially higher price. That doesn't reach a level of assistance or combination or conspiracy among the two, right? There's no allegations here that actually show the two were working together. They were not. And so that was the basis of the dismissal here. And that's why, Your Honor, the claims are insufficient and don't survive this stage. But if I know my time is really short, I really want to turn to one issue because the court didn't reach it. But there's no dispute here that a 3-year statute of limitations applies to the causes of action. There's also no dispute that the causes of action accrued in April 2011. The claims here were asserted in April 2019, 5 years after the expiration of the statute of limitations. So the only way that these claims are saved is if the relation back doctrine applies or the saving statute applies. And here they do not. And I know the court is intimately familiar with these tests, but the relation back doctrine requires there to have been a mistake. There was no mistake here. The appellant waited opportunistically for Scottish Ray to go bankrupt. He went down to the Cayman Islands and acquired the claims from the company's Cayman liquidators. That's not a mistake. The other thing is that they have to be united in interest, the old party and the new party. Here, the director defendants and Cerberus are not united in interest at all. The Court of Appeals has said there's got to be a legal jural relationship. And one more point on relation back, Your Honors. It has never been used in this context, where you have a new plaintiff who is Davis standing in the shoes of the company now. He's not asserting any claims of himself, asserting new claims. Those are claims that belong to the company against a new defendant. And that's Cerberus, who had been dismissed from this action entirely, including by this court.
Thank you.
Relation back doctrine.
Thank you.
Thank you, Your Honor.
Okay. Jean-Marie Atmian? You have to unmute your mic if you are trying to speak.
I was trying to speak, Your Honor. Thank you.
Great. Hi.
I represent Mr. Port, and I'm from Mayor Brown. The breach of fiduciary duty claim against Mr. Port was dismissed because there isn't a single allegation as to him in the complaint. There's no conduct specific or otherwise attributed to Mr. Port. And you don't even have to read the second amended complaint to know that. My able colleague didn't mention his name once in his presentation today. He referred to Mr. Chapman about 15 times, and he referred to Mr. Bloomer several times, but never Mr. Port. Now, in dismissing, trial court focused on two main factors. First, Mr. Port was never on the special committee that reviewed the transaction. For that purpose, a group of disinterested directors was appointed, and they retained independent professionals in assessing the transaction, legal counsel, and financial advisors. The second key factor that Justice Sherwood relied on was that Mr. Port had no connection whatsoever to Cerberus. Affiliated, that's mutual. That is the Scottish largest unconflicted shareholder. So what does that mean? Well, that means that Mr. Port's interests fully aligned with the interests of Scottish Re, not Cerberus. It was in Mr. Port's interest to pay Cerberus as little as possible. Now, those two critical facts beg the question as to why Mr. Port was named. Well, the answer lies in a candid passage in plaintiff's brief to trial court. That's in the record, page 442, where he concedes that the only reason Mr. Port is still in the case is that he is one of only two directors left over whom trial court has personal jurisdiction. Justice Sherwood dismissed the other 8 in 2014. Plaintiff simply has the wrong director. And the plaintiff admits that the alleged misconduct relates to other directors on the special committee, not Mr. Port. That's why trial court concluded that there isn't a single specific act or omission attributed to Mr. Port. Much less is there an allegation of conscious dishonesty or intentional infidelity, and that is the standard for breach of fiduciary duty under applicable Cayman Island law. So it's a subjective test. The director's state of mind is the issue, and there is no such allegation. And that oral argument in response to a question from trial court, Mr. Brenner conceded that he could not plead, quote, individualized allegations by name. And Justice Sherwood said, well, isn't that the whole ball game under our laws? Now, this lack of specificity, I submit. Yes.
You're out of time. I thank you. We have your briefs and the record. Thank you. Mr. Brenner, you have 2 minutes.
Thank you. First on Mr. Port, the reason Mr. Port is a defendant in this case is because the evidence that is in the record and before this court is that he played a key, if not determinative role in this transaction going forward. It's in Exhibit 8, which is at record 618. It's in Exhibit 9 of my declaration below at record 619 and 20. It shows that Larry Port's view is critical. It's one of 2 data points that determine whether or not this transaction go forward. He gave the thumbs up. He shouldn't have. That's why he's in this case. The question that Justice Mazzarelli asked about, what about the assistance of Cerberus? The Cayman law expert said, you have a conspiracy claim under Cayman law by procuring the management of a company to enter into an unfavorable contract in breach of fiduciary duty. That is Halkerston 55 in the record. It's unrebutted by their expert. That is what the emails show Jonathan Bloomer, a Cerberus representative, doing in connection with this transaction. Finally, on statute of limitations, Justice Sherwood addressed this in granting motion for leave to amend and letting us file the second amended complaint. The touchstone of the relation back doctrine in New York is notice. Our very first complaint in this action included claims against Cerberus based upon the Orkney transaction. As Justice Sherwood recognized, they cannot possibly assert surprise or prejudice as to these claims, and therefore, as in this court's whole decision in Bellini, the subject amendment does not frustrate the principle underlying the purpose of the statute of limitations. Separately, the savings statute applies. We filed a derivative claim against Cerberus. This court found we didn't have standing. We had a 6-month cure period. We cured. No one's questioning our standing anymore. Mr. Davis was the plaintiff in the first case. Mr. Davis is the plaintiff in the new case. That triggers the savings statute, Your Honor.
Thank you. Okay, and last but not least, GCS Second versus Merchants Hospitality. Mr. Alonso, you have 5 minutes.
Good afternoon. My name is Mark Alonso of Alonso, Andalcar, and Thatcher. I'm here on behalf of the appellant, defendant, Merchants Hospitality. Before I start, I just want to say for some reason my cases always wind up at the bottom of the calendar. And this was one of the most interesting afternoons of argument that I have ever gotten to witness. And I say that fully knowing that in 12 minutes, I may not feel that way so much. But for right now, this was great.
Yeah, for us, Mr. Alonso, it was a slow day.
Well then.
And Mr. Alonso, you lost 2 minutes of your time.
I talked very quickly. Let me just say, I know you know what the case is about. My clients assembled from 92nd and 93rd Street at enormous expense, all the buildings with the idea of development.
This is Judge Joyner. The question is, was there a closing, right? Because according to the arguments, because there was no closing, your client's obligation returned the 1.5, I guess, I forget how much money it was.
135.
Right. Money never ripened, right?
Not, well, sort of. I believe that the intent was, what this agreement was read as, was as an instrument for the payment of money only, a bridge loan. And it wasn't. There were corresponding obligations relating to exclusivity. But in my view of the contract, all of those obligations of the plaintiff were never even considered. And it wasn't just about the closing. I think the problem is the agreement itself, because the agreement contemplates what happens if there's success. The problem is, notwithstanding two competent counsel on both sides, Morris and Cohen and Paul Hastings, nobody thought about what's going to happen if nothing
works. When they don't hire you. That's what happens when they don't hire you.
And I seem to constantly be here defending somebody else's or criticizing someone else's contract. But in that context, of all these counsel, nobody seemed to think of the downside. And they talked about, well, the whole reason for the verbiage, the closing as contemplated by the contracts, was the idea that either my client is going to be there with the plaintiff as a builder doing the deal jointly, or my client will go out and get another builder. But the reality is, and analogous to what was argued in Buchanan,
your client sold or assigned it to somebody else because the person that was yes, because the person that was supposed to go into the building, the school, said, I'm backing out, I'm done.
Right, but keep in mind, within that, the court never examined the fact that the builder we brought in was brought in because he had a pre-existing relationship and knowledge of the tenant, and shortly after they got in, they both exited the transaction, and Mr. Kogan's client was then pitching the school to go into a different location outside of New York. So there are a lot of facts that when you look at this as an instrument for the payment of money only, don't tie in. But the biggest one is that there was no contemplation of a loss. And I say this in a very simple way. Look at this from the context of, this is a wasting asset.
So maybe I'm missing something, or I read the wrong case, but the plaintiff loaned your client money, right? And at the end of the day, to me, it simply said that the deal doesn't go through, you got to give me back my money.
Well, that premise is that...
Am I mistaking something? Am I missing something?
Yes, and that's where you said he loaned the money. He didn't. He put in a contribution to buy himself exclusivity, a right to negotiate, a right to work with our lender, and then...
Hold on a second. Now, how do you respond? How do you respond to what I thought I read in the record, where the contract said that the monies that you were going to get, could only be used to extend the period of time in terms of extending the closing time or extending the time to actually finish the deal. There's no exclusivity there. That's a specific purpose for the money that they're giving you.
No, the exclusivity was on forcing us out of the market. They told us as part of this deal, we had to not deal with anyone else, no other builders, no other lenders. And the concept was that left us with no time at the back end to salvage the deal, which would have been fine if two things had happened.
Did I miss something? Was that in the contract what you just said?
The exclusivity is in the contract. We were forbidden to market the deal. They locked themselves in. So that $1.35 million was not a loan. It was
Mr. Alonso, this is Justice Kennedy, and maybe you can point me to it because I don't see anywhere in the agreement where it indicated that the funds were considerations for an exclusivity period and that the funds were not returnable. Maybe you can point me to it because I don't see it.
Number one, it's in there, but it's not tied to it. It says it's for this. They specifically said you'll contribute the money. But if you do two, and again,
Hogan is just smiling.
The way of the contract writing, they should have said, here's what you're going to do. Put money in, negotiate with our lender, work with our tenant, and on the other side, here's what we're going to do. We're going to exit the market.
Mr. Alonso, this whole agreement had, I think, the dual purpose. There was a joint venture aspect of this agreement as well as the money aspect of this agreement. And I don't think the two may ultimately end up in the same place, but they were on different tracks.
Yes.
And one was depending on the other. So good. We're on the same page there.
Yes, absolutely. The problem is they contemplated.
You can tell me what that problem is on your rebuttal time. Okay. Mr. Kogan, you're up. 5 minutes.
Thank you, Your Honor. Harris Kogan of Blank Rome for the respondent. You know, it's interesting in its brief, the appellant first claimed on several occasions in the brief that there was no reasoning to Justice Cohen's decision. He didn't give any reasoning. And what was incredible was that the transcript of the hearing and decision was not included in the record on appeal initially. Because if you read the transcript, Justice Cohen's decision was entirely reasonable.
It's 40 pages.
It was left out of the record on appeal until we said to the other side, why isn't it there? They then included it. And if you read that record, Justice Cohen went through every argument. And what he said is there is only one reading of the contract. And that reading of the contract is that if a closing occurs, you have to pay the 1.35 back. And Justice Cohen said that is exactly what happened. And he called the reading by the appellant.
And Mr. Kogan, this is Judge Owing. And the closing did not necessarily mean defending closing, a closing.
Right.
Has to happen.
Exactly. What the judge said, and I'm quoting, he said, the closing contemplated by the contract was the development project of the properties, quote, which indisputably occurred. Now let's take a look at what this contract was and this exclusivity and so forth. What the agreement was my client, DCS, the respondent, was contemplating whether to go into a deal. And the appellant needed money in order to get an extension of time for the contract. And we gave $1.35 million, which could only be used to pay for an extension. And this exclusivity was for 14 days. 14 days. If we didn't do a deal within the 14 days, if we didn't sign a JV agreement within 14 days, appellant was free to go ahead and negotiate with anybody else. What he had to do was, when the closing occurred, pay back the money. And the closing occurred. And in fact, the appellant received over $14 million, didn't tell us about the closing, and didn't give us back the money.
Well, that closing counsel, but that was because he assigned the rights of the purchase of the property to another party, right? And then
simultaneous. Yes, there was a simultaneous assignment and closing. On the same day, he assigned it to Maplewood. Maplewood closed, and in fact, the plaintiff,
you just want back your 1.35 million.
That's all that I want.
They can keep the 14. I just want to add something. And certainly the defendant was not required to be a party to the closing. They weren't required to be a party.
The defendant was not required. All that there had to be was a closing. What the court below said was the concept of saying I could flip the contract, get $14 million and not have to pay you back is absurd. And I believe that
this is a very interesting thing. Your client's not seeking to get a part of that $14 million.
No, we are not. We decided we didn't want to be a JV partner when GEMS, the educational institution, left the deal. When it and let me just address one thing. You know, the appellant has tried to create issues of fact. Oh, he may have been talking to GEMS about another deal. Oh, he didn't negotiate in good faith. There has been full discovery in this case. Not only was there full discovery with the deposition of my client in this case, there was full discovery in 3 litigations in between GEMS and the appellant, and my client's deposition was taken. And all that they say in their affidavit in opposition to the motion for summary judgment is potentially there might have been something going on. And despite full discovery, what came out was that there was no communication between GEMS and my client. There was no deal between GEMS and my client. This concept of trying to create an issue of fact or screen conspiracy just doesn't hold any facts to support it. It's a straightforward contract. We gave the money, we're entitled to it back.
Thank you so much. Mr. Alonso, you have 1 minute.
Justice Owing, you said, wouldn't they have asked about part of the 14 million? And I submit to you, that's the problem with the contract. We spent 18 million and we only got back 14 million. So why would we, if you use the analogy, we had a horse that's about to die, it's going to the glue factory. And at this point, somebody says, I'll pay for feed for another couple of weeks so you don't have to kill the horse quite yet. Why would we borrow that money knowing we had a losing problem and a time deadline now? Number 2, all the quotes from the transcript, they're not what's actually the decision. The decision is 1 page. What he has done is take the transcript and say that every question asked of me, every idle thought, every bit of colloquy is part of the decision. And I also point out to you that in every business transaction, whenever you look at that, the very first thing is one of the terms of accounting is last in, first out, or first in, first out. If you've put $18 million into a deal and it's turning out potentially badly, would you give back the guy who made you keep it alive a little longer, 100 cents on the dollar? Just as Justice Owing said, wouldn't they want to think about getting part of that 14 million? Well, wouldn't the good lawyers, had they not written an ambiguous contract, have said, wait a minute, maybe there should be something if there's a shortfall that instead of getting 100 cents on the dollar, if we lost 25 cents or 22 cents on the dollar of our 18 million, shouldn't they get back something pro rata as well? And that's why intent is important.
Mr. Alonso, only if there's a joint venture. All right, thanks.
Thank you.
Thank you. This concludes the session of the Appellate Division, First Department. Good evening, all.
Good evening.